Let's start. I know it is the last panel, but bear with us. Bear with us because it is the last panel, but it comes right after the previous one is perfectly connected to, I would say, I think there is a link somehow. And we will keep you awake for sure. So this morning, everything, not this morning, was already after lunch, but we started everything saying that arbitration and arbitral awards are arbitration is the procedure where you do see more reference to UPICC or the Bonnell principles, use the Don expression. What we tried to do now was not, of course, to repeat what you have heard until now. We will focus on arbitration, but we will do it looking at concrete issues. Probably somehow Lauro will be more general in giving us some data and information, and then we will get into some specific issues. So you'll see how concretely arbitration might apply the principles. Now, the panel is a panel of extremely well-known scholars, all involved as professors at the university, but also with practice either as a lawyer or arbitrator or as an advisor to some institutions on for instance, the Advisory Council of UPICC. And so somehow we try to put together complementary experience, but with a general background, which is the one of being able, as scholars, to systematize somehow the issues. So we'll start with Lauro Gama, who's a professor at the Catholic University, Pontificia Catholic University of Rio, of private international law and international contracts. Then we will give the floor to Christina Ramberg, who's professor of private law at Stockholm University. And then we will finish with Dominic Spenser Underhill, who was teaching, I think, formerly at Queen Mary. Are you still teaching at Queen Mary? Yeah, at Queen Mary, and also a very well-known arbitrator, and he was working also in one of the companies I'm against in a number of arbitrations. So it's, but it's so we keep distance. And so I will say, as I said, I give the floor to Lauro for his more general introduction, and then we will pass to the more specific, if I can say, speeches of the other two panelists. Lauro, please, you have the floor.
Mesdames et messieurs, mes amis, ladies and gentlemen, good afternoon. First of all, let me thank the UNIDROIT, and in particular Maria Clara, Inácio, and Ana for the opportunity to be here with you, celebrating the 30th anniversary of the UNIDROIT principles. The UPICC have been the object of my study and affection for a long time. I'm going to talk about the use of the UNIDROIT principles in arbitration. And without further ado, let's first examine what aspirations okay, okay, good, great. What aspirations did the UPICC have when they were first published? Back in '94, when the UPICC were published, they aspired to become a transnational legal framework for the resolution of international business disputes. And arbitration seemed to be the ideal setting for its application for two reasons, basically. First, because of the UPICC's non-binding and non-legislative nature, which was and still is to a certain extent unfamiliar to state court judges. And secondly, because of the parties' freedom in the arbitral setting to choose the rules of law applicable to the merits of the dispute. 30 years have passed, and how have the UPICC fared in arbitration? In this presentation, I will first show you some statistics about the application of the PICC in resolving disputes, both in the arbitral and the litigation settings. And secondly, I will focus on figures on the application of the PICC in ICC arbitration. I will also illustrate these figures with a few cases where the PICC have been resorted to as the governing law, namely as the rules of law chosen by the parties, as the law determined by the arbitrators to govern the dispute, and thirdly, as the subsidiary law applicable to interpret or supplement the otherwise domestic or international law applicable. And finally, I will put forward some conclusions on the perspectives of the PICC in arbitration. And don't worry about taking notes. I'll be happy to email my presentation to anyone who would like it. To better understand the upcoming statistics, let us just recall the multiple usages of the PICC as the law applicable to the merits of the dispute. The PICC may apply as primary law or as secondary or subsidiary law. As the primary law governing the contract, they may be chosen by the parties, either directly or indirectly, or determined to be the applicable law by the court or arbitral tribunal. As subsidiary law, they may be applicable when the primary law governing the contract or the merits of the dispute is a domestic law or an international instrument which needs to be interpreted through the lenses of a transnational contract legal framework or supplemented by it. Now let's check some figures drawn from the UNILEX database about the application of the PICC over the last 3 decades. If we took all the 580 cases reported at UNILEX, we would note that, first, the PICC are by far more frequently applied as subsidiary law, i.e. to interpret or supplement the domestic law applicable, or the CSG. That represents roughly 79% of all cases reported to UNILEX. Conversely, they are seldom applied as the primary law, as a system of law governing all aspects of the contract. If we took again the same 580 cases reported at UNILEX and divided them into 5-year periods, we would note that in the first 10 years, approximately 75% of the disputes where the PICC were applied were arbitration cases. By contrast, in the last 2 decades, this trend has significantly changed in favor of state courts applying the PICC more often than arbitral tribunals. What do these figures indicate? Well, frankly, it's hard to say. It often takes a long time, months, if not years, from the actual application of the PICC by a court or arbitral tribunal to its voluntary noticing to UNILEX. For example, the most recent arbitral award reported at UNILEX dates from February 2022. We all know, furthermore, that most arbitral awards are confidential, which prevents their publication. Be that as it may, roughly speaking, these figures indicate as a starting point that historically, And despite the extraordinary growth of international arbitration in the last 4 decades, today the PIC are apparently more frequently used in state court litigation than in arbitration. Also, the PIC are rarely used as a system of law. Rather, they are mostly applied as subsidiary law to support the solution found under the domestic law applicable or the CSG. And this would contradict the PIC's aspiration to become a transnational legal framework for the resolution of international business disputes in the arbitral setting. Moving on to the second part of my presentation, I would like to focus on the application of the PIC in ICC arbitration. I have chosen to examine the arbitration data provided by the ICC for 2 reasons, basically. First, the ICC has a long-standing reputation of being the most active and international of the existing arbitral institutions. And secondly, the ICC court has a large database. And thirdly, I have friends at the ICC. As we all know, since the adoption of the ancestral model law on international commercial arbitration in the mid-80s, parties are free to choose the rules of law applicable to their dispute, including a system of non-state laws such as the PIC or the UNIDROIT principles. Most, if not all, arbitral domestic laws or arbitration laws and arbitral rules provide that in the absence of choice by the parties, arbitrators are free to determine the applicable law by voie directe, without resorting to a conflict of laws regime. Thus, unlike what usually happens at the court setting, in arbitration, the PIC can be freely chosen as the law governing the dispute, either by the parties or by the arbitral tribunal. Now, despite the parties' freedom to apply the PIC to the merits of their dispute, it rarely happens beforehand in ICC arbitration. As we can see from 2022 statistics that were put together by Gilles Cuniberti in a very interesting article on the most attractive laws in arbitration, only 1.6% in only 1.6% of the new cases filed in 2022 before the ICC court, a non-state law had been chosen by the parties in their contract. And from that 1.6%, only 0.3-0.4% was the UNIDROIT, the law chosen by the parties. In other examples, parties choose general principles of law, international laws, more general language directing to non-state law. Furthermore, data provided by ICC indicates that contracting parties resist to choose the PIC as a system of law applicable to their dispute. As we can see in the last 10 years, the PIC have been chosen beforehand in the contract in only 0.3% of the new cases filed before the ICC. Now, moving to the end of the arbitration, i.e. to the award rendered by the arbitrators, the figures are not impressive, I'm afraid. In the last 10 years, the PIC have been applied in ICC awards only in 23 cases. And that involve cases involving state parties, or when the PIC have been applied in conjunction with the provisions of the applicable law and when they were applied as governing law. And these 23 cases have to be compared with the total amount of ICC awards approved in the last 10 years, which was 5,327. So whichever way you look at it, the underlying trend appears to me at least a bit clear. The choice of domestic legal systems, either by the parties or the arbitrators, still prevails in the arbitral setting. Now, I would like to turn your attention to some selected cases where the PIC were chosen and applied in ICC arbitration. The first case was kindly provided to me by Professor Klaus-Peter Berger, and it's being published in an upcoming article wrote by him at the Journal of International Arbitration. And in that case, the parties had contracted the pathological choice of law clause. In order to avoid all the uncertainty of that pathological clause, early on in the arbitration, they agreed to use the PIC as the governing law of their dispute. And in doing that, the arbitral tribunal applied the PIC as the law governing the contract and referred to 23 provisions of their 2016 edition. The arbitral tribunal thus treated the PIC as a self-contained legal system of transnational contract law, instead of piecemealing the application of its provision. On another case that was also submitted to ICC arbitration, the UPICC was chosen as the primary law determined by the arbitral tribunal in the face of an absence of choice by the parties. In that case, the arbitration clause simply provided for arbitration with no choice of law clause in the contract, and in the absence of such a choice, the Romanian party claimed the application of its own law, Romanian law, whereas the Indian party claimed the application of Indian law. The arbitral tribunal, after hearing the parties, decided that the UNIDROIT principles were the most appropriate law or rules of law applicable to the dispute, given that there was no common intent of the parties as to the choice of a national law to govern the contract. And also, in this case, the arbitral tribunal applied the UNIDROIT principles as a system of law governing the whole of the dispute. It actually applied the UNIDROIT principles to matters relating to limitation periods, to non-performance, to the duty of achieving a specific result, and so on. In a pending case, the UPICC has been invoked as subsidiary law to fill in the gaps of the laws. This deals with an investor state-owned beer market in Cuba have chosen in their any dispute between resolved the common Indian and Cuban, and there's no such private law. There are the provinces. The Canadian, who is represented also the has principles in order to support its claims. Has not objected to drug principles. Resolved yet, or a partial award. At least the UNIDROIT principle applied as subsidiary steps of the CSG matters of losses relating to in conjunction instruments of European. The question is, why seldom chosen as the law applicable? Usually said that the first, a non-legislative. Second, because they are incomplete as a system of law. And thirdly, because transaction lawyers just don't know them. 10 years ago, we celebrated the 20th anniversary of the PICC at the neighboring Angelicum. Our dear friend, Professor Ralph Michaels, suggested on that occasion that believing in the PICC was a matter of faith rather than one of legal science. In his view, the PICC could only play a limited role in international contract law, that of a background law, of a residual law. I respectfully disagree with Professor Michaels for a number of reasons. First, the PICC is, and it's well known, a striking example of the positive influence of soft law instruments in the reshaping of modern or contemporary state law. A number of modern civil codes, including the 2020 Chinese Civil Code, the 2015 Argentinian Civil Code, the 2016 French reform of the law of obligations, have been inspired by the PICC. We definitely live in a world where the boundaries of state law and non-state law are increasingly fluid. Second, the increasing recognition of non-state law as an authoritative legal source also favors the adoption of the PICC as governing law. In Latin America, the radiation effect of the 1994 Mexico Convention has defeated a long-standing tradition against party autonomy and the recognition of non-state law as a legal source. Today, in Venezuela, Dominican Republic, Panama, Argentina, Paraguay, Uruguay, and likely also in Chile, the law recognizes the parties' freedom to choose transnational principles as the law governing the contract, and the court must uphold that choice. This promotes legal certainty and predictability in the regulation of international transactions by means of transnational principles such as the PICC. Last but not least, the irreversible trend towards promoting transparency in international arbitration will likely foster the adoption of the PICC as governing law. Transparency in international arbitration includes, among other measures, making awards available to the public in general, to interested organizations. In the years to come, more arbitral awards applying the PICC will be published and discussed. Thus, the PICC will likely play a role in the development of commercial law as relevant as the one traditionally played by court judgments. Since we are in Rome and near the Vatican, I would like to close my presentation by making reference to one of the most renowned works of art of the Renaissance, the School of Athens by Raffaello. The school is a place where individuals elevate themselves through knowledge and research. The ancient masters, Plato and Aristotle, above all, are celebrated for their merits, and there is no religious reference showing their inspiration coming from a divine source. In my view, the UPICC have proved their merits in the last 30 years. They proved to be very worldly in solving contract disputes. They also remained a strong, inspiring ideal for modern international contract law. Definitely, the PICC are not just a matter of faith. Thank you.
Thank you, Lauro, not only for the many interesting metaphors somehow that you used, but also because I'm sure there are a lot of data and information in your presentation that need discussion. And I think as we decided, we will leave the debate after the three interventions. So now we will see how some of these issues can be solved or addressed by arbitration. Asking Christina to take the floor on this matter. Thank you.
Thank you. I am very honored and happy to have been invited to participate in the celebration of the UNIDROIT Principles 30th anniversary. I remember very clearly in 1994 when my doctor father, Professor Grönfors, received the book. And he shouted in the university corridor, and he wasn't a shouting person. And he said, "This book will make history." And he was correct, of course. I also remember another shouting, and this was between me and Joachim Bonnell. I visited UNIDROIT the first time in 1995, and he and I had a very vivid and angry discussion. We were in disagreement regarding the contra proferentem rule in the principles. And we were not able to reconcile our disagreement. We were, our throats were aching. But I really loved the way he was willing to listen to a very young, unexperienced researchers and to take the time to discuss the matter with me. I still think I was right and he was wrong. Now, 30 years ago, I had anticipated that we would see frequent references to the UNIDROIT principles in contracts. But my anticipation was wrong. In my experience, contracts almost never make references to UNIDROIT principles. And we heard in the former panel that this is also the experience from practitioners, with the exceptions of Eckhart Bredemann. Maybe tomorrow we will hear other panelists explain that they have experience in other industries of references to the UNIDROIT principles. But I dare say already now, it is very hard to change the traditions of lawyers who draft contracts. Such lawyers are generally conservative. However, lawyers acting as counsel in disputes, they are more prone to change. The reason being that any argument that may serve their client's interests is worth trying. Consequently, we see references to UNIDROIT principles as an argument in disputes, in national courts as well as in arbitral tribunals. So the UNIDROIT principles, they kind of sneak in through the back door. not through the main entrance via the contract, but when a dispute is argued. I have quite extensive experience of providing expert reports on national Swedish law to arbitral tribunals. And in international arbitration, as you all know, the parties must prove the content of the applicable law. And this is often done by expert reports and the hearing of experts. I come from a very small jurisdiction, which is hard to understand for foreigners. And furthermore, to complicate matter, it lacks a comprehensive private law code. So how is national law best explained to arbitrators who are unfamiliar with the Swedish national law? The arbitrators are well experienced in contract law, but may find Swedish law strange and awkward. How can I convince the arbitrators that Swedish law makes sense? How can I make the arbitrators confident that what I state in my expert report is accurate? And how can I pinpoint the real peculiarities of Swedish law as opposed to the seemingly strange rules in Swedish law that make no real difference in outcomes? Well, you all know the answer. It's simple. I describe Swedish law in relation to the UNIDROIT principles. And generally, international arbitrators are familiar with the principles. They understand how UNIDROIT principles relate to their national law. So when I relate Swedish law to the UNIDROIT principles, the arbitrators in turn relate to their national law, and the principles serve as a bridge or connector between the applicable law of the contract, the dispute, and the arbitrator's own national law. So let me give you just some brief concrete examples. The most frequent matter that appear before international arbitrators concern the interpretation of contracts, the principles chapter 4. And the methods of interpreting contracts in Swedish law are very similar to the principle, the UNIDROIT principle rules on the interpretation of contracts. And therefore it's very useful to refer to this chapter. As I mentioned before, the argument I had with Professor Bonnell, one rule in the UNIDROIT principles is not corresponding to Swedish law, and that is the contra proferentem or contra stipulatorem rule. So it's very useful to explain that Swedish law does not have a rule corresponding to the contra stipulatorem, which is the text in Article 4.6. But Swedish law acknowledges the relevance of the contra proferentem rule, which is another rule, the heading of Article 4.6. And as we are discussing future development and revisions of the principles, maybe this contradiction between the heading and the content of Article 4.6 can be revised. Another frequent matter before international arbitrators concern hardship. And lately, of course, many international arbitrations have addressed hardship due to the COVID pandemic, the war in Ukraine, and the shortage of semiconductors, etc. And I find the definition of hardship in the Principles 622 very useful to provide guidance on how to assess whether there is hardship. And it's fascinating how the UNIDROIT principles exactly corresponds to Swedish law in this respect. And the effect is that in order to constitute hardship, well, doesn't work in practice. Extremely rarely, if you apply the hardship rule in UNIDROIT principles, you very rarely reach the threshold of hardship. Many jurisdictions and arbitrators find Swedish law strange when it comes to the legal effects of hardship, because our statutory law allows modification and adaptation of the contract. And in order to persuade the arbitrators that this is perfectly makes sense, it is useful to refer to the UNIDROIT principle legal effect of hardship and say Swedish law is not different from the UNIDROIT principles. I have now explained how the UNIDROIT principles can be used working as an expert on national law in arbitration, but also in my role as arbitrator, I find them very useful in order to understand the applicable national law. So I can use the principles as a basis for questions to the experts. And this is, you may know it has become increasingly common to have the two experts available at the same time, hot tubbing. And then to ask the questions to the experts, how does whatever law is applicable relate to this article in UNIDROIT principles, and they can respond to it. I find that extremely useful. I will end my presentation here in order to enable time for discussions.
Thanks a lot, Christina. I think we keep having very interesting elements to discuss. We close the circle with Dominic and English law and good faith or whatever in concrete arbitration. Thank you.
Thank you and good afternoon. I'm the token common lawyer this afternoon. And so I will do my best to amuse and entertain and possibly to educate you for 15 minutes before we end for the day. What I'm not going to do is give you a summary of the English law of good faith in the next 15 minutes because I can't do it. No one can do it. At least not in this earth. And what instead I'm going to do is try and whet your appetite, because if this is a subject that interests you, I hope what I say may cause you to read a bit more and so on. What I am going to talk about is going to be set out in a much more detailed paper that's going to be published, a more academic document. So don't be concerned about taking lots of forensic notes, just sit back and enjoy. Now, it may surprise you to know that in 1766, before my country decolonized its curriculum, and we still had North America as a colony, Lord Mansfield said this in a very famous case that's taught at universities but not anywhere else, called Carter and Burn. Good faith forbids either party negotiating a contract by concealing what he privately knows to draw the other into a bargain from his ignorance of that fact and his believing to the contrary. I mean, it's beautiful 18th century English, but that was said by an English Supreme Court judge or House of Lords judge 250 years ago. 150 years ago, in a case called Walters and Morgan, Lord Campbell, who was the Lord Chancellor at the time, held that a tenant who had procured an extension of his lease had done so through a lack of good faith. Lurching unglamorously to the 21st century, the Consumer Rights Act of 2015 defines a contract term that is unfair as one that does not accord with the principles of good faith. This is English law. The idea that English law doesn't understand what good faith is is simply wrong. We have a different way of approaching it, and you'll be familiar with Lord Hoffman's leading speech in Chartbrook, Holmes and Persimmon, which is the leading authority where the Supreme Court of the United Kingdom dealt with a case under the UNIDROIT principles. It tackled that very issue. And Lord Hoffman observed that the notions of good faith under the UNIDROIT principles come from French philosophical interpretation of principles of contractual interpretation, not English ones. And he, with a spirit of despair, said, well, they really are inimical in that respect. Now, whether you agree with him or not, it doesn't really matter. But this is not something that the English are completely unfamiliar with. It's just we approach it in a different way. And that's really what I want to discuss now. It might also interest you to know, my iPad's gone to sleep, it'll wake up. We have, under the English common law, a duty of utmost good faith in the law of partnership, which we've inherited from the Romans, which is rather topical in the circumstances. We have a duty of trust and confidence in employment contracts, which is a duty of good faith. That's exactly what it is. And we have a duty of good faith in fiduciary contracts as well. Principally between, for example, lawyer and client. There's no doubt we do. However, what we don't have, and I'm going to just clarify what I'm going to focus on, the common law and the civil law, the common law and the UNIDROIT principles bang up against each other in three main areas. One is the formation of a contract and its interpretation. The second is the performance and hardship, and third is in remedies. I'm only going to focus on the first of those three because I've only got 10 minutes, right? So give me a break, but that's what I'm going to do. What we don't have in my country is an implied duty of good faith in the negotiation of contracts. That is something which we've never had, and I doubt we ever will have. And the fundamental reason, which you may all be very familiar with, is that to the English mind, the negotiation of a contract is an act of gentlemanly warfare, where everyone is trying to actually exert their own wishes over the other and eventually give up and form some kind of consensus. But it is an act of effectively an assertion of rights against someone else that someone tries with varying degrees of success to accommodate or not. And that is what caused Lord Hobhouse in 1992 to describe a wide principle of good faith to be repugnant, is the word he used, repugnant to the English notion of contract negotiation. So good faith doesn't really feature for us in the negotiation of contracts, but it does feature, it changes shape, and it does feature in other ways. We have it in statute, for example, in the Misrepresentation Act of 1967, which makes it unlawful to lie and be dishonest in the negotiation of a contract. Not only that, but you can't misrepresent facts when you negotiate under English law, when you negotiate a contract. You bestow remedies on your counterparty if you do that. We don't call it good faith, but that's effectively the upshot of it. There is so moving on from the negotiation of contracts, we come to an implied duty. Does English law imply a duty of good faith into a contract? And we met some kind of hint about 11 years ago in a case called Yan Sang, and Mr. Justice Leggett, who is now Lord Leggett, one of the members of the Supreme Court, advanced with some spirit the principle that there should be, there are in certain circumstances areas where, whilst not of universal applicability, a principle of good faith, a duty of good faith, can be implied into certain sorts of contract. And that idea met favor in a case in 2019 called Bates against the Post Office. And the notion of what we call relational contracts began. And relational contracts are long-term contracts that require very high degrees of cooperation in their performance. I haven't got time to set out a topology or to iterate the various factors of relational contracts. But this idea of contracts that were huge, closely performed, required high degrees of trust and cooperation to be effective at all, could have implied into them a duty of good faith. Where life gets really interesting, though, is express obligations of good faith. And this is very often missing from academic texts. What happens where you have a contract that actually says in the contract, we will have a duty to act in good faith? And it won't surprise you to learn what happens where you have a contract with an English common lawyer where you agree to adopt the UNIDROIT principles or something resembling to it. What do the English courts or an English arbitral tribunal or an arbitral tribunal seated in England do with that? And the answer is, well, they don't just ignore it. They have actually quite a lot to say on the subject. And it began really in a case called Ray Gorin in 2013, where a duty of good faith was considered in the case of shareholder agreements, where shareholders and companies specifically said that there should be an act of good faith between them to act honestly. So we interpret good faith very much in terms of a moral or quasi-ethical position of acting honestly. Another one is to act within the spirit and intention of the agreement. That's another aspect of good faith as we saw it. There was a further case called Unwin and Bond in 2020, not long ago, where a rather ambitious judge thought that he would dilate on the principle of good faith in a shareholders' agreement and said, well, it means to act honestly, it means to be faithful to a common purpose, not to use the power of a contract for an ulterior purpose, and to have regard to the other party's interests, not only your own. And this should be ringing an awful lot of bells with an awful lot of you. This was said by an English judge 4 years ago. All right? So we're not miles apart, or are we? Because 2 years later, the Court of Appeal, in a case called Compound Photonics, said, well, we don't disagree with the judge in Unwin and Bond, but we wouldn't quite go that far. So typical English style, which is, yes, but. And that's how I've earned my living. Yes, but. Honesty remains, there's no doubt, honesty remains a principle of good faith under English law. And what the Court of Appeal was inclined to do in that case is to say that the requirements of good faith are derived as a matter of interpretation or implication from the other terms of the contract. So what you understand good faith to be isn't something that metaphysically imposes itself upon the contract as a kind of ghost in the machine. What it actually is something that emerges out of the contract by virtue of what the contract says. And that's a true common law approach. So it seems to me, with a little bit of intellectual imagination and courage, that there is some common ground. So what has this got to do with arbitration? Not a lot, but has it? I think it does, because were you aware that the articles of the London Court of International Arbitration specify 2 obligations on good faith on everyone who adopts their rules? And the interesting thing about the London Court of International Arbitration rules is the default is London as the seat. So the LCIA expects arbitration seated in England to apply a doctrine of good faith in interpretation of their own rules. And the rules are, from memory, Articles 16 and 32, I think, 14 and 32. Puts a duty of good faith on the parties to perform the arbitration within the spirit of the rules, and then Article 32 imposes the duty on the tribunal to act in good faith and the parties as well. And I'm going to end in a minute with this thought. There is a recent case called Emirates Trading, where it was one of those tiered dispute resolution agreements where the parties had to engage in what were called friendly discussions before they could start an ICC arbitration. And there was a fight about whether or not they did this, which was rather boring. But the interesting thing is, what did the court make of this clause? Now, the way to understand this is that through the eyes of the English courts, arbitration is a type of ADR. That's how they see it. Arbitrations, no matter how fancy arbitrations are, no matter how expensive and grand and all that stuff, it's a type of ADR because by the definition of ADR in the civil procedure rules, it's a way of resolving a dispute outside the normal court process, and that is arbitration. It's a matter now of public policy that disputes in England and Wales should be resolved wherever possible without litigation. It's been public policy now for about 25 years, but the public policy is becoming increasingly more vivid as the courts apply this principle more aggressively. So to the English courts, what they really, really, really want you to do is arbitrate when you said you will. And in the case of Emirates Trading, it was, we'll have a little chat before we arbitrate. So the end game was the arbitration. And the question was, had the parties engaged in friendly discussion? And the court said that they will imply a duty of good faith into that obligation to have a discussion. It says so in terms. They don't say what that good faith means, because in the common law tradition, it means what it means on that particular case, in that particular circumstance, in that particular set of parameters. But it seems to me, and this is where I'm guessing, that it's not very far to step from that to saying that if you have a dispute resolution agreement containing not so much negotiation and arbitration, but arbitration, and if not arbitration, state court litigation, the court will imply into the arbitration agreement a duty of good faith. It seems to me, I can't give you an authority, it's just my own thought. Having been very pleased with myself with that thought, I then thought, actually, I'm not so pleased with myself because no one seriously disagrees with me, do they? Do they really think that an arbitration agreement doesn't have implied within it a duty of good faith? So it's a rather academic point. Anyway, I'm coming to the end, but the conclusions I'm encouraging you to draw is that when it comes to the UNIDROIT principles, the English common law, although it's got problems with the principles, it's not so far apart as you might think. And there are grounds for optimism if one is going to be proselytizing and ecumenical about it, to try and see much more common ground than there used to be 30 years ago when, and this is what I end my presentation on, it was about 25 years ago that Professor Brodeman and I were co-counsel in an arbitration which applied the UNIDROIT principles. I think I was the first English solicitor to do that, regarding the contractual rights emerging from an orbiting satellite. No one could agree on the governing law in that particular case. And I think it was Eckert and François Desmonté at the time who thought it would be a much better idea to apply the principles. And that is exactly what happened. And it was successful. So I do have a bit of form with UNIDROIT arbitrations, but my interest in the common law and the principles is whetted by my research for this presentation. Thank you very much.
I'm sure we have a lot to discuss, and I would say that if you notice that Joachim today started also mentioning cases where the role of the principles in a comparative analysis or use as a tool, in fact, for comparative method is also one of the possible way forward and tools. And I think it's really also from a conceptual point of view is extremely stimulating to see what the principles can do and how they can serve the purpose of having legal culture to dialogue, in fact, a lot. So now I think we have really a lot and we are getting to the end of the day. And so the last debate before we take a break. Yeah, so one by one, please, yeah, you can.
Just two comments. Lauro, on your talk about applying the UNIDROIT principles to contracts and how rarely they are applied as a governing law. In the construction field, where construction contracts are very detailed, for example, the FIDIC conditions, just the general conditions, are over 100 pages long. Some people argue, and I think with justification, that there's no problem in applying the UNIDROIT principles as a governing law to a very detailed contract, because, well, there's the less, one of the disadvantages you highlighted was the UNIDROIT principles are incomplete. Well, that is really addressed if the contract is very detailed. And it may be particularly appropriate to apply the UNIDROIT principles in preference, for example, to the law of a developing country where the law itself may be quite incomplete. I just wanted to make that comment, Lauro. In other words, comprehensive contracts may be lend themselves better to the UNIDROIT principles than the normal ones. And then on the comment of Christina Ramberg, it reminded me of when we were preparing the 2016 edition of the FIDIC, of the principles. I remember one of the members of our working party, and I can't remember her name, but she was dean of the Geneva Law School. She made the comment that, I come from just a small country, and I'm asked from time to time to give expert opinions. And because people aren't familiar with Swiss law, when I give an expert opinion on Swiss law, wherever I can, and where UNIDROIT principles are consistent with that, I will also cite, in my opinion, the UNIDROIT principles. So that's entirely consistent with your experience, Ms. Ramberg.
Dear Chris, well, I think the lady you referred to is Christine Chapuis. Yes. I was thinking about your comment. In my experience as a member of the ICC court, I saw a number of cases where the FIDIC contracts were at issue involving Romanian parties and basically the state and the private party. And in those cases, I think that the state would really resist to choose another governing law, but its own law to govern the dispute. And that's what I would say about developing states, or yeah. Thank you.
I see many votes. Let's start. Anna, Judith, and yeah, we start for women. Anna.
Thank you very much. I have a question. My impression, perhaps it's a wrong impression, is that while it might not be so easy for parties, and we see that there are not many instances of parties when they draft the contracts for the first time, they draft a contract to draft a choice of law clause referring to the UNIDROIT principles as the governing law of the contract. One way the UNIDROIT principles are already more influential and might become more influential is at a different stage, at the stage of a dispute resolution, even if the original contract does not contain this particular reference to the UNIDROIT principles. And I'm thinking of alternative dispute resolution going beyond arbitration even, so which is something that is growing. And it might be that at this later stage, because of the situation and the fact that the parties would like to find a solution, the reference to this body of, let's say, neutral principles and rules may prove to be more useful than referring to a specific domestic law which might be considered biased by one of the two parties at that particular stage, instead of at the time of concluding the contract in the first place. So I'm not sure whether this is something that you have experienced or something that might ring a bell somehow. Thank you. I'm, for example, looking at possible frameworks for alternative dispute resolution as the one APICC has developed, where there is a reference to non-state law as a possible possibility to solve the dispute.
Well, Anna, I am going to disappoint you. My experience is that there is a lot of talk of ADR, and there are many attempts to formalize ADR, which I think is a contradiction in term. The whole idea with the ADR is to be non-formalistic and try to find a solution not based on formalistic procedures and applicable law or UNIDROIT principles or anything. So I think that the more we try to formalize ADR, the less successful is ADR going to be. And I from a practice point of view, and I have more experienced practitioners here in the room, but I don't see that it will be very frequent to say, let's go for ADR and apply the UNIDROIT principles.
Giuditta.
Thank you. Thank you for a very interesting panel. Many different things I could spend the whole night commenting it. So I will restrict myself to a question that was growing in my head while Dominic was speaking, and then Chris' comment made me change it a little bit. So comprehensive contracts subject to the UNIDROIT principles, because the comprehensive contracts already have all the procedures and explain when you can exercise a remedy, etc. Now, the UNIDROIT principles, among other things, they have this duty about exercising a contractual remedy in good faith. And the question there is, what does that mean? Does that mean that if you exercise a remedy in accordance with the wording of the contract, that is per definition in good faith? Or do you have to check every time that in those under those particular circumstances, the exercise of that particular remedy is in good faith or not? That is a question that could be clarified with it would be an advantage if it were clarified. But that's a question where English law comes into the picture, because Lord Leggett and Yam and all his decisions about good faith and so on, he's been very insistent in saying that good faith has always been there in the English legal system, and it's a modest requirement. I remember him saying honesty and respecting the branch standards, but, for example, not restricting or contradicting express contract terms. So good faith, an implied duty of good faith could not be, a duty of good faith could not be implied to restrict the possibility to exercise a contract right, even if under the circumstances it could seem like an unbalanced exercise. Yeah, you understood my question.
I have. If I may say so, I think that's beautifully put, that's exactly his position. and if I may say so again, you've understood him perfectly. I mean, this is the inherent tension within the common law, is that you have very deep-seated ethical obligations to be honest and to engage in a sense of fair dealing with your counterparty. The other side of that, the shadow side of it, is you are entitled to negotiate and assert your rights as much as you possibly can. And it's the bargain that is struck, no matter how weird it may look. That's what it is. Now, equity and law come to the defense of those who are truly disadvantaged by unfairness. The Unfair Contract Terms Act, which is now the Consumer Rights Act. We have a doctrine of duress. We also have a much more controversial fair means duress doctrine, which a case called Pakistan International Airways against time travel in 2021 concerned itself with, where the Supreme Court was invited to impose a duty of good faith on people trying to negotiate the renewal of a contract. And the Supreme Court said emphatically, we're not going to do that, because this is the bargain they want to strike. And there's no question of anyone being dishonest, and there's no question of duress in that particular case. So there is that tension. So Lord Leggett and the Mr. Justice Leggett, as then was in the Yang Sen case, was bridled in by subsequent judgments saying, well, yeah, what we didn't mean was there is a wide principle of good faith that's applied everywhere in all contracts all the time, all at once. We're not saying that, and that is the law now. But what we can do is, in certain circumstances, start to identify good faith as it, in my view, as it always was there. We just called it different things, and we have different ways of forming contracts and so on and so forth. But you get the point. So yes, there is that tension. There isn't a wide doctrine of good faith under English law. We all know that. But my point is, it's not as simple as that. It's simplistic and lazy to think, oh, well, that's the end of the conversation then, as far as UNIDROIT goes. No, it's not the end of the conversation. You just have to look a little harder and think a little more creatively to see common ground. That's my point. Thank you.
Thank you. Eckhart, please.
The take home is definitely to write into the contract, if it's English law, something on good faith. The question I have is language, which we have not mentioned so far. Over 50% of the population are dealing in bad English, like people like me, like most of us here, which we call global English. And we are absolutely unable to speak it at the same level of excellent as our token and any other good, well-trained common lawyer. So I like to write something in the contract is governed, the parties are aware that the parties are represented by non-native English speakers using language, English as a language of convenience. I always try to put in some kind of English clause, which together with the good faith might that trigger that, and that's my question, that chapter 4 on interpretation or something else is being used. And sometimes I even try to add in the bottom chapter 4.
Yes, I mean, I think there's, if you're drafting, certainly if you want to, if you're a civil lawyer who's conceded common law ground and have the, well, okay, well, we'll have English law, forget the Australians and the United States at the moment, because they're going slightly off on a tangent. So let's stick with England and Wales. The very least you should do, as you have correctly identified, Eckhart, is say, and they'll perform this contract in good faith. That's better than nothing, because the English courts in a dispute will seek to identify what that means. They won't just pretend it isn't there. They will, in the true common law tradition, give weight to every single word in that contract. And there's authority on this, I don't have time to go in, but it will be in my paper, is various recent cases explain how they work out what the phrase good faith means in that particular contract. And this is why the relational contract and Mr. Justice Leggett's judgments are so interesting. I think there are reasons to be cheerful, actually, on this score. I've said that point 3 times now, but which means I'm being consistent, at least, in my decision making. But
Thank you. Now, Pietro, please.
First, a curiosity to Lauro. I was very curious about that case with the Romanian and the Indian company. Of course, I imagine a Chinese arbitrator, just to make a joke. I was very much curious about the fact of whether anybody tried to challenge that award, just because out of the blue, the arbitrators were referring to the UNIDROIT principles. You didn't mention that there was an explicit acceptance of the UNIDROIT principles in that case. And then I have a comment for Dominic, which you have just anticipated, because you have just said, forget about US and Australia. And I just have in mind a couple of examples where basically you are surrounded by good faith, because okay, we know that under US law you have the concept of good faith, and surprisingly enough, I have a recent example of good faith in a memorandum of understanding. You know, as an English lawyer, you will say this is an agreement to agree. This is not binding. But in that case, we were criticizing our Texan counterparty for breaching this memorandum of understanding, and the General Counsel replied by saying, maybe there can be a fee to be paid by us for breach of fiduciary duties, which was quite common. I mean, once the contract is signed, I was surprised to see it also in the negotiation phase. And then just 2 weeks ago, I received a letter from an Australian law firm, an Australian company, proposing to have a mediation in good faith. I know that this is not governing law, this is procedural, but I was quite surprised, but of course in a positive way. So just a comment.
Certainly. Going to the developments of good faith in Antipodean and North American law at the moment. There was an attempt, I've forgotten the name of the case off the top of my head, about 10 years ago, where one particular judge got terribly enthusiastic about these various authorities, and counsel brought the judge's attention to all these authorities, particularly from New Zealand and Australia, saying, well, look what's happening in the common law. It's good faith everywhere. Why not us? And the judge said, oh, yeah, I can see that, and made his judgment. It went to the Court of Appeal. It was Lord Justice Moore-Bick in the Court of Appeal said, I don't think so. Because there is strong resistance from senior jurists in my country against what they describe as a wide principle of good faith. And you've got to look at the language that's being used, the wide principle, a wide doctrine, a comprehending idea. That is what we have a problem with. But when you narrow it down, there are ways through the gaps. That's the point. So the Antipodeans and the North Americans so far have not breached the wall of the Court of Appeal yet in my country. Not quite yet.
Well, isn't it often the case when comparing civil law with common law that we start from different extreme positions, and then we have all the exemptions, and the same guy wins the same amount of money in the end? And this is how, going back to language, this is how the way we express the law is different. And so we misunderstand each other. And this is, of course, also why the UNIDROIT principles are wonderful.
If I can say, this was one of the points of Alberto Mazzoni all the time. I remember since I was young, since I met him for the first time. Please.
Well, Pietro, thank you very much for your comment. Actually, in that case, the parties, each one of them, the Romanian and Indian party, had claimed their own law to be applicable, and the arbitral tribunal invited them to consider the application of the UNIDROIT principles. And therefore, after hearing them, the arbitral tribunal decided in favor of the application of the UNIDROIT principles, and that should be the way, you know, to go in any arbitral tribunal. And I have not seen a case where the arbitrators would have applied the UNIDROIT principles, just, you know, imposing them on the parties before hearing them, because of the non-surprise principle. And you know, just adding on to what Dominic and Christina have just mentioned, well, coming from a civil law jurisdiction, I believe that this comprehensive idea is progressively being narrowed down by courts in view of concrete cases. And I know for a fact that in Brazil, for example, you know, the general principle of good faith can never represent, you know, creating new obligations that have not been contracted for by the parties, or favoring one party over the other without, you know, a justification. And I recently also participated in a case where Spanish law applied, and the Civil Code of Spain, the good faith principle under the Civil Code of Spain also is interpreted by case law and doctrine as being this. You know, you cannot just apply it as a something that has no limits, so to say. So these positions are coming together somehow.
I've just, funnily enough, found the citation for this Australia no thanks case. It's MSC Mediterranean Shipping against Cottonex Anstalt of 2016, where the judge in the first instance was terribly impressed by the Australian and the North American position at the time. And it was indeed Lord Justice Moore-Bick who said that he disagreed with the first court's acknowledgement and reliance on what he described as an increasing recognition in the common law world, that is Australia and the United States, of the need for good faith in contractual dealings. And that was 2016, and that's remained the law ever since. Yeah.
Anyway, just a final comment. I will always remember, as a general principle of English law, your comment, yes, but.
But it's yes, but getting to yes. Yes, but yes.
I think we can still take one final question, please.
Sure. Thank you, madam. A very conceptual question I would like to raise. Good faith, in fact, in English, a very dangerous term for the continental lawyers. In the negotiations in an arbitral tribunal, we had this problem among the arbitrators. We have bonne foi objective and bonne foi subjective in French. We have guter Glaube and Treu und Glauben in German. Treu und Glauben, or bonne foi objective, means conduct of a reasonable man at the street, bonus pater familias. So when we have when we would like to translate a text from English into Turkish or into another European language, it is very difficult to translate good faith in, for instance, in French or in German. It looks like sometimes
treu und glauben, that means bonus pater familias. Sometimes guter Glaube, that is bonfa subjective. That is just a conceptual question. It has nothing to do with the discussions in this matter, yeah, in this room.
You can always answer yes, but.
Yeah, what is the question is how to translate it. And I think the answer is you can't. I think this is the fundamental, that there's this rather curious epistemological assumption that all language is perfectly translatable into another language, and said no one ever. That's never been the case. And I think there are certain circumstances, particularly circumstances that derive from the uniqueness of national jurisdictions, that you can't translate certain things. I mean, I'm a honorary professor at Queen Mary, and I lecture in ethics. And it seems to me that the way, if you're going to make any progress in this, is rather than obsess about juridical meanings of words, is to try and get to the underlying metaphysic of them. And where did they come from? Where did the notion of good faith come from? Forget what the words are, what's the underlying meaning of those words, which is a fundamentally an ethical consideration. That, I think, is very fertile ground for overcoming the problem you've identified. But I've given up after 35 years in practice thinking that everything can be translated neatly into another language, because it certainly can't, in my view.
I agree, it's extremely hard to translate this word, but I think a more fruitful way of moving forward to understand the meaning of the words is actually not to have an historic digging, but instead to provide concrete examples, concrete cases. And this is what the UNIDROIT principles do in the comments and illustrations. I think by reading the comments and illustrations of cases, we understand, okay, of course I can rely on a contractual express right in the contract that I have, even though we have said in the contract that it should be we should apply good faith. Because I would be most surprised if in any jurisdiction you would have a contractual express right and say you can't apply it because that would be against good faith. And so we have a concrete example, and I think this is the best way to understand the meaning of various notions in different languages.
I don't see, do you want to, yeah, please.
I just recall there's a footnote in, I think someone mentioned Ewan McCormick on contract law, the English author on contract law. He's got a footnote there where he said, good faith has a wide spectrum of meanings. And this is in line with what Christina is saying. It seems to me if you define what the range is that you consider to be good faith, it can be done. There doesn't need to be a dispute about it.
Chris, that's a very interesting observation. And one thing that's always troubled English judges is being boxed into a prescriptive definition of what good faith means, because in the true common law tradition, you look at each individual case and the law evolves, or as some lawyers would say, is revealed as you explore it. And to constrain it with language in that way is a problem, and that is a solution. I think that's right. It's certainly one way through. I can't do better than rebut the Goodrich footnote with Sir Roy Good, who may or may not be in this room, who said in 1992 about good faith that he said about English lawyers, I'm not sure we quite know what it means. And he was being coy and fun. But I don't think that that's the issue, is what does it mean rather than what does it do? And until we ascertain the epistemological value of that phrase, we're going to be struggling. But I do think, back to UNIDROIT, I think it is a very fertile ground to explore commonality and make progress in this difficult area of language.
Sorry. In addition to the United States and Australia, there's the famous Canadian case also on good faith. So England is becoming isolated.
Well, no change there then, is there?
Singapore.
Judita, I leave you the last word.
Oh, well, thank you. Well, it was actually music to my ears, the last two comments or answers about how fertile ground it can be to investigate what is actually the content of good faith in the UNIDROIT principles, because I really think that, okay. About the cases and about the impossibility to translate and the danger of using language, there is the comparative law school that was founded by Rodolfo Sacco in Italy, which has created a methodology which is usually defined as the common core methodologies based on cases. So is not making the comparison on the basis of rules, definitions, doctrines, principles. It is making the comparison on the basis of cases. If the contract says that you can terminate and the circumstances are like this, can you terminate, yes or no? And then some countries will say yes, some countries will say no, and then it is up to the comparativists to find out, to give the definition. Was that good faith or was that something else? That permits to avoid all these pitfalls of using words in a way that, that can have many meanings or no meaning at all. So I'm sorry, that was just a hiccup of comparative law. Thank you.
In a way, this is how the UNIDROIT principles were discussed and created. So just to conclude by citing the UNIDROIT principles on this. Thank you.
Thank you. We are at the end of the first day. There are no conclusion at the end of the first day because it's just the night break waiting for tomorrow morning. So we resume tomorrow at 9. What time? Sorry, I don't even know the timing. 9:30. And thanks a lot for the very nice discussion we had until now.